Arbitration and Conciliation Act 1996 Preamble Section 1. The Arbitration and Conciliation Act 1996 was enacted taking into consideration model law of conciliation rule adopted by United Nations Commission on International Trade and Law UNICETRAL. Part 1. Arbitration. Chapter 1. General Provision. Section 2 to 6. Court as defined in the Arbitration and Conciliation Act 1996 means a principal civil court of jurisdiction in the district and include the High Court. As per Section 3 Clause 2 of Arbitration and Conciliation Act 1996, a communication is deemed to have been received on the day when it is delivered to the addressee. International commercial arbitration means an arbitration relating to the dispute where at least one of the party is an individual who is the national or the habitual residence in any country other than India, a body cooperated which is incorporated in any country other than India, association or the body of the individual whose central management and control exercise in any country other than India, a government of a foreign country. Which statement is not accordance with the provision of Arbitration and Conciliation Act. Arbitration tribunal shall not, during the arbitration proceeding, make interim award. The international commercial arbitration is an arbitration where at least one party is a body cooperative incorporated in any country other than India, a body of individual whose central management and control is exercised in any country other than India, the government of a foreign country. Under the Arbitration and Conciliation Act 1996, the court means a principal civil court of original jurisdiction in the district. Chapter 2. Arbitration and Arbitration Agreement, Sections 7 to 9. Which one of the following dispute can adjudicated upon through the arbitration? Arising out of legal relation, arising out of contractual relation, arising out of commercial relation. Which one of the following is not an essential condition as per arbitration agreement as per Section 7 of the Arbitration and Conciliation Act 1996? An agreement must be registered. The arbitration award is defined in the Arbitration and Conciliation Act 1996 include interim award. A party seeking an interim measure from a court would file an application under Section 9 of Arbitration and Conciliation Act. Which one of the following statement is correct? So far as Section 9 of Arbitration and Conciliation Act 1996 is concerned, a party may apply to the court for seeking appointment of the receiver by way of interim measure even after making an arbitral award by the arbitral tribunal. Interim measure by a court under Arbitration and Conciliation Act 1996 include appointment of receiver, securing the amount of dispute in the arbitration, for preservation, interim custody, sales and good, which is subject matter of the arbitration agreement. The commencement of the arbitration proceeding is not depend on the interim relief being allowed or denial under Section 9 of Arbitration and Conciliation Act 1996. Supreme Court in which case held so? Firm Ashok Trader versus Gurmukh Das Sujal. Chapter 3. Composition of Arbitral Tribunal, Section 10 to 15. The parties to an arbitration. are free to determine the number of arbitrators provided that such number shall not be an even number. An arbitral may be of any nature unless otherwise agreed by the party. If there is no agreement between the party to an arbitral proceeding in respect of the number of arbiters, there shall be one arbitrator. Under the Arbitration and Conciliation Act 1996, the mandate arbitral tribunal terminate when the arbitral withdrawal from his office. When the arbitrator withdrawn from the office, the party agreed to terminate the mandate incompetency of the arbitrator. An application under Section 11 of Arbitration and Conciliation Act 1996 can be filed either in the Supreme Court or in the High Court. In an arbitration between two parties before the arbitrator appointed by the Chief Justice of the High Court in exercise of the power of the Section 11 of the Arbitration and Conciliation Act 1996. The rival party have filed a claim against each other. When the arbitration was in advanced state, the party are in the opinion that arbitrator is like to reject the counter claim of both the party. The parties jointly inform the arbitrator that they are not willing to the arbitrator before him and stop appearing before him. The party thereafter are entitled to appoint another arbitrator to start arbitrator proceeding de novo. A party seeking appointment of an arbitrator through the High Court or its designated shall be make a request under Section 11 subclause 6 of Arbitration and Conciliation Act. An arbitrator agreement provided an arbitration of the four arbitrators under the Arbitration and Conciliation Act 1996 to be constitute the management for the arbitration by sole arbitrator. If within 30 days the party fail to appoint their arbitrator or the arbitrator fail to appoint the third arbitrator, the arbitrator shall be appointed by the Chief Justice of the person instituted designated by him. If the arbitral proceeding where the party failed to appear the oral hearing or failed to produce documentary evidence, the tribunal has the power to continue the proceeding and give it the award. The arbitral award rendered in the arbitral proceeding commended before the coming into force on the Arbitration and Conciliation Agreement are to be challenged as per provided in the Arbitration Act 1940 unless and otherwise agreed by the party. Chapter 4 Jurisdiction of the Arbitral Tribunal, Section 6 to 17. The Arbitral Tribunal shall not be bound by the court or the proceeding or the Indian Evidence Act unless and otherwise agreed by the arbitral proceeding in respect of the particular dispute commence or date on the request of the dispute to be tried refer to arbitration received by the respondent. Chapter 5 Conduct of Arbitral Proceeding, Section 18 to 21. An arbitrator is not bound to follow which one of the following enactment: none. In the absence of the agreement between the party, arbitration proceedings are said to have been commenced on the date on which the request referred to the dispute of arbitration is received by the second party, in which case Supreme Court held that power to grant interim measure under Section 9 The Arbitration and Conciliation Act 1996 extend to international arbitration as well as Bharat International Arbitral Trading SA 2002 SCC 105. Chapter 6 Making of Arbitral Award and the Termination of Proceedings, Section 28 to 33. After the arbitral award is made, each party shall be derived a signed copy of the award, which section of the 1996 Arbitration Act permit to engage in the conciliation process even while the arbitration proceedings are on. Section 30. Arbitral tribunal may correct any computation error, any clerical or topographical error, or any other error similar nature occurring in the award of suo motu within the 30 days. Chapter 7 Recourse against the arbitral award, Section 34. An application for setting aside the arbitration award is filed under Section 34 of Arbitration and Conciliation Act 1996. The provision for setting aside the arbitral award is laid down in Section 34 of the related act. Which one of the following is not a ground of setting aside the arbitral award under Section 34 of Arbitration and Conciliation Act 1996? Incapacity, none of these. An arbitral award under Arbitration and Conciliation Act 1996 has a status of the decree only after a time of 3 months. For making an application to set aside has expired, such application have been made, refused, in which case Supreme Court held under Section 34 of Arbitration and Conciliation Act of the court can examine the validity of international award. Oil Natural Gas Corporation Limited versus Shaw Pipe Limited 2003 SSC 705. An arbitration award made set aside by the court if it is conflicted with the public policy in India, if the party is under some capacity. Under the Arbitration and Conciliation Act 1996, an application for setting aside an arbitral award must be made by the party after receiving the award within 3 months. Finality and enforcement of arbitral award. Chapter 8, Section 35 to 36. An arbitration award is enforceable as a decree if not challenged. True. Section 35. An arbitration award can be enforceable under Section 36 of Arbitration and Conciliation Act 1996. Chapter 9 Appeal. Section 37. An appeal under Section 37 of Arbitration and Conciliation Act 1996 read with the ordinance of Section of 2015 shall lie refusing to refer the party of arbitration under Section 8, grant for refusing the granting or refusing the grant of any measure under Section 9, setting aside or refusing to set aside arbitral award under Section 34, all these. Chapter 10 Miscellaneous, Section 38 to 43. Limitation Act applied to arbitration as it applied to other civil proceeding. True. A has lent money to B under writing. Agreement contain the arbitration clause. The agreement does not specify at the time of repayment. Rather, a money where repayable demand A after the 5 year of the date when the loan was made demand a money which was not repaid to B. The parties could not arrive at the consequences of the appointment of arbitrator also. A filed an application under Section 11 of the Arbitration Act Arbitration and Conciliation Act 1996 before the Chief Justice of the High Court for appointment of arbitrator. B is in the response to said application contained in the claim of A stated or buried, thus arbitration is not appointed. The Chief Justice is bound to appoint arbitrator, leaving the plea of limitation open for the decision in the arbitration award. Part 2. Enforcement of certain foreign award. Chapter 1. New York Convention Award. Section 44 to 52. Part 2 of the Arbitration and Conciliation Act 1996 related to enforcement of certain foreign award. Part 3. Conciliation. Section 61 to 81. Which one of the following statement is correct? Unless otherwise agreed by the party, conciliator shall not act as an arbitrator. Unless otherwise agreed by the party, conciliator shall not act as a representative of counsel, a party in the arbitrator or judicial proceeding in respect of dispute that subject of the conciliation proceeding. Unless and otherwise agreed by the party, the conciliator shall not present by the parties witnessed in the arbitral and judicial proceeding. All. Miscellaneous. The provision of Arbitration and Conciliation Act 1996 have interpreted being uninfluenced by the principle underlying the 1940 Act. This observation was laid down in Sundaram Finance Limited versus NEPC Limited. The Arbitration and Conciliation Act was enacted in 1996. A civil court before which action is brought in the matter of subject, the matter of arbitration, while referring the party to the arbitration on application of the party under the Arbitration and Conciliation Act 1996 required to dispose a suit in the term of the said reference. Arbitration and Conciliation Act 1996 has replaced the Arbitration Act, Arbitration Protocol and Convention Act, Foreign Award Recognition and Enforcement of 1961. In which one of the following cases it was held by the Supreme Court that Part 1 of the Arbitration and Conciliation Act would be not applicable. International commercial arbitration held outside India, and therefore such award would be the subject of the jurisdiction of the Indian court when the same are sought to be enforced in India in the accordance with the Part 2 of the said Act. Bharat Aluminium Company etc. versus Kesari Aluminium Technical Service Incorporation etc. Balco 2012, Supreme Court 552. Which one of the following is incorrect statement? A. Which one is correct? An arbitration award must be in writing and signed. An arbitration award include interim award,